Mr. Speaker, return to page 9. Two bills have been moved out of the uncontested to third reading. First one on page 9, House Bill 2127, relating to best interests of the child, maximizing time spent with each parent. Page. He's the one who has to have it.
Delegate from Alexandria, Doug Levine.
Mr. Speaker, speaking to the bill.
Delegate has the floor.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, HB 2127 seems like a very innocuous bill. What it does is it looks at the factors for child custody, and it kind of gives an uber requirement. It doesn't look at the basic 10 factors. It says that when appropriate, courts shall assure frequent and continuing contact with each parent when considering these factors. Now, I have long felt it's a problem in the Virginia Code that the factors do not include child abuse and domestic violence. And while ordinarily it'd be fine to give frequent and continuing contact to each parent, it is not okay, in my view, to give frequent and continuing contact to a parent who has committed child abuse or domestic violence. Under the current code, we only consider child abuse and domestic violence when it occurs within the family. We do not consider it when it happens outside the family. There was a case in Richmond where a man beat up a pregnant woman so badly he served a year in jail. When the mother of the child was suing for custody, he beat her up as well when she was pregnant. But the court wouldn't consider the prior conviction because it wasn't in the code. Many of you have heard the case of Tyler Strong. Tyler Strong was beaten very badly by his father for 2 years. That same man cracked a 2-year-old skull against the wall, but it wasn't his child. It was his girlfriend's child. So the court said, not in the code, doesn't count. Now some have said, well, courts should figure this out. They should figure out when appropriate. They should figure out it's necessary and proper. These are obvious cases. But there's more than a dozen cases, and I've given them to folks. I've been on this, most of you know, for about 4 years now, where courts have not. Courts actually take the language we write here very seriously, and oftentimes they look at the text and treat the text very seriously, and they don't look at factors outside the code. So they're not looking at domestic violence, they're not looking at child abuse when it occurs outside the family. Furthermore, this code section says that we can disregard whether you let a child be with another parent if they've committed domestic violence, sexual abuse inside the home. But outside the home, they do it to their girlfriend or the child, well, that's not a factor to be considered. So as this bill is currently written, it would assure appropriate, frequent, and continuing contact with a parent who is known to be abusive, who's known to have committed child abuse and domestic violence. As such, I regretfully have to oppose this bill. Thank you, Mr. Speaker.
Delegate from Virginia Beach, Delegate Davis.
Mr. Speaker, will the Speaker rise for a question?
It's on third reading. It's on third reading.
Speak to the bill, Mr. Speaker.
Delegate has the floor.
Thank you. Mr. Speaker, I appreciate the gentleman's comments, but he may not realize that this exact language was pulled off of Virginia Code 20-124.2, which actually uses the term when appropriate. Well, children are frequent and continuing contact with both parents when appropriate. Mr. Chairman, in 20-124.2, it applies that exact language to custody. All we're doing by putting this in the other section is also applying it to visitation to ensure that that same standard is applied to visitation, not just to custody. So, Mr. Speaker, I would suggest that if the delegate does have a problem, he may want to bring a bill next year to address both these sections of code.
Shall the bill pass? I'm sorry. Okay. Clerk, erase the roll. Delegate from Fauquier, Delegate Weber.
Thank you, Mr. Speaker. I just would like to point out, speaking to the bill.
Delegate has the floor.
I'd just like to point out Section 9, while considering the following: any history of family abuse that has been defined by 16.1-22.8 or sexual abuse. If the court finds such a history, the court may disregard the factors. Please support the measure.
Delegate from Alexandria, Delegate Levine.
Briefly, Mr. Speaker, speaking to the bill.
Delegate has the floor.
It says you can disregard the factors in subdivision 6. It does not say you can disregard the factors in HB 2127, which are not in subdivision 6. And furthermore, family abuse in section 9 does not include child abuse and domestic violence when it occurs outside the family. I have brought a bill for 4 years straight to include it in the code. It has not escaped this body. And because child abuse and domestic violence are not in this code, I cannot vote to have frequent contact with a child abuser. Thank you, Mr. Speaker.
Shall the bill pass? Clerk will close the roll.
Ayes 80, noes 16.
Ayes 80, no 16, the bill passes.